to a sitting juror. And the motion that I bring before Your Honor is to have that juror excused because of the conversations that took place on the record in this case with that juror. And although we have great empathy with the court as trying to do everything humanly possible to make the conditions for this jury tolerable, livable, and in a way that this jury can eventually hear all the evidence and reach a verdict, we are compelled under the law to bring to the court's attention what we believe was a violation clearly of the constitutional rights to an independent and fair jury of our client, Mr. Simpson. And we believe that the court, although noble in its desire and purpose to try to alleviate any potential financial hardship that this particular juror has suffered, has in fact created a legal condition that now has put this juror in a special place. And what
action has the court taken that puts this juror in a special place at this point?
Well, the court's indicated action. The court has taken no action whatsoever. But
the court said to the juror, give me a couple of days to look into this.
That's right. But the court also indicated, I believe, that there would be some effort made on the part of the court that would, in fact, result in a financial hardship of this juror being relieved. And since that financial hardship has been discussed amongst other members of the jury by this juror, we feel now that that juror, just from the conversations with Your Honor and from Your Honor's indication that the court would be willing to look into financial aid as well as other support from the court regarding a rental income property, that has now affected this juror in a way that it might cause other jurors to feel that they are entitled to similar types of consideration, to similar types of compensation. The court has not made any ruling whatsoever, nor has the court done anything yet. However, I think it was clear to that juror, who was very comfortable at the end of the conversation, that this court, as it always has towards jurors, was going to do everything possible to try to alleviate that hardship. And we believe just in doing that, this juror now may feel a special kinship to Your Honor.
Well, I've done this for a number of jurors. I have gone out of my way to make sure jurors have been transported out of state to attend families' funerals and gone out of the way and spent county funds to do that. Juror 247 the other day had a problem that we had to deal with, that the court made special efforts to do that. Are you suggesting that every juror for whom this court has made efforts, special efforts, unique to that juror, that those jurors should be excused? If you're making that motion,
no, I have
because your position is inconsistent with the court's treatment of all the other jurors.
No, and we commend the court, and in many instances joined with the court and acknowledged that those things were justified. What this case and this issue, we believe, is different because this involves substantial proposed financial compensation retroactive for several months, not something protracted, something that may come up in the future, something of an emergency, or something that would come up just once. This is something that involves a financial issue, which we believe is separate and distinct from the other very personal issues that the court has shown great empathy for, and properly so, to the jury. and we have always concurred with that.
I seem to recollect, Mr. Shapiro, that when one of the jurors was excused and you chose to take a writ to the Court of Appeal, that you urged that this court should go to a higher level of vigilance in keeping each and every member of this jury intact and on this jury. And you took the position that it's not just reasonable cause regarding excusing jurors, that I should take a heightened level of scrutiny to each one of these decisions. So I think this is an inconsistent position with your prior position.
That is absolutely correct, but we believe in this case that by separating one juror based on financial considerations, that it violates the basic tenets of the United States Constitution and the Constitution of this great state, and gives unequal compensation financially in a significant way to one juror as opposed to 12 others and 2 alternates. And I am sure that all of these jurors have tremendous hardships that would greatly be alleviated with the largesse of this court and by any type of compensation. But we believe constitutionally that that violates Mr. Simpson's rights to have a fair and impartial jury where each juror is treated as one and the same. And this gives the impression, whether it is right or wrong, but it gives the appearance that special treatment is being given to a juror. And we are not saying that Your Honor has singled out this juror for special treatment. This juror came to Your Honor. This juror demonstrated financial hardship, and this juror was apparently in a condition where this juror could no longer continue on this jury because of the great financial hardship this juror was suffering based on some rental income property. And the court sought to alleviate that problem. It is our position, however, that such relief, however wonderful and compassionate,
Noble was the
noble, however noble, that's right, that's a better word, however noble the court's desire was, it is not a constitutional right that this court enjoys.
All right, I take it you'll file your motion.
Yes, Your Honor, we have also, just for the record, we have filed the motion, and the other thing that it does, Your Honor, is it puts a juror in a position where the juror now might feel that if this continues, and if the court is going to compensate a juror for lack of income in a rental property, that this juror may have an added interest in prolonging any type of...
Ms. Clark, that's not necessary.
Ms. Clark apparently has a funny bone that has been touched. That this juror might have a financial incentive for wanting to prolong any type of deliberations. Now, we don't believe realistically that any juror wants to do anything other than end this and end this quickly. But we pointed that out in a footnote, and I think it's important to add.
All right. Thank you, counsel.
Your Honor, and we'd like to get an answer as soon as possible so that we can take a writ on this matter. We feel it's that important a constitutional issue.
Well, we may have somebody come forth from the public and volunteer to leave this problem outside of the court. Who knows? It may go away.
Thank you very much, Your Honor, for your consideration.
You're welcome, Mr. Shapiro.
Appreciate it.
As always.
Thank you.
All right.
Probably the last issue for today, Your Honor, may deal with the scope of rebuttal regarding certain lay witnesses and where we're going in this case.
We did have the June 17th issue still open.
Yes, we'll do it. Perhaps we can take that up tomorrow. But what I'm concerned about, Your Honor, is Ms. Clark indicated today that the people might rest on Thursday. If that be the case, we'd like to know which other witnesses they have pared down. You had directed Messrs. Douglas and I think Fairlow, instead of Mr. Darden, to get together. They have taken Steve Jensen, Stuart Roper, and Leonid Rubin off of their list. But we still have a list that would be roughly 56 people, less the few who've been called. We need to know who they're going to call in order to get down to this, to finish this case by Thursday. We'd be entitled to those list of names. We'd like to have those now. There may be another issue regarding the 617 events, and an issue regarding Dr. Dutton. I guess that'll be coming up next week. So I'd like to have that at this point, because if they pared other people down, if they're not calling other people, we need to know now so we can be ready to get this case over with. We want to resume our case. We have witnesses who are out of state, and one in particular we're going to be asking the court probably either tomorrow afternoon or Thursday morning to help us bring back, and a new witness to bring out here. So we want to do that as soon as possible, so there's no delay for next week. So may we have that, Your Honor, some indication of what are the witnesses they paired off, who's coming up next, who will be their witnesses to finish the case? If by Thursday, that's within 3 days, and we're entitled to it.
All right, I assume that they are going to offer at this point, a modified Paratus video, that they're going to offer Mr. Diedrich as to fabric impression. Is that correct, Ms. Clark? All right.
Wouldn't it be easy to hear from them, Your Honor?
Oh, those are the issues we just finished discussing, so those are pretty obvious, wouldn't you say?
Yes, they are, and I'm trying to get, okay, yes, we knew about those, Your Honor.
Okay.
Trying to find who else they have.
And we are concluded with the glove people. So what does that leave us, Ms. Clark?
Leaves us with Bill Wozniak. We have to litigate the Bronco fiber issue. That's, I would indicate to the court that would be, it's very brief. That's admitted. The Bronco fiber witnesses are 3 in number, 15 minutes each. We ask for the court, also the Ackers, Lawrence and Nancy Ackard, Christian Anders, George Field, Don Thompson, for Dr. Dutton, Gretchen Stockton, and that goes to the matter I have to say that.
That's about 3 days worth.
But obviously, then it's clear they're not going to finish on Thursday. That was a pipe dream. How can we finish on Thursday with this number of witnesses? Wozniak, that's preposterous. And I haven't heard Popovich or anything.
No, it's not preposterous, it's optimistic.
Well, it's more than optimistic. I'm optimistic, Your Honor. That's preposterous. Your Honor, the issue is, I think we should be realistic, because that brings me to the last motion I'd like to at least have the court think about. I told you earlier this morning that I think on behalf of the defense, on behalf of Mr. Simpson, we herewith ask this court to modify the sequestration of this jury. The court will recall that approximately, I guess now, 10 days ago, we met in chambers regarding a jury who shall remain nameless, and the court made a representation based upon what we told Your Honor, that you expected this case to be to the jury by the middle of September, on or about September 15th. We're not going to make September 15th, clearly. We'll be lucky to finish this case next week, unless there's some paring down. And so I think that it's unfair. I think that from a standpoint of all of our credibilities, during voir dire, we told this jury they'd get the case in April, as I recall. And so it seems to me that we've reached a point where this jury should no longer be made to suffer. Our client has had to suffer, and we hope to alleviate this situation very soon. But these jurors have been brought in from the outside, and it seems to me the court should seek to modify the sequestration. And this court is very, very innovative when it wants to be, and it seems to me this would be an appropriate time to set up some kind of procedure where these jurors can go home at night and meet someplace in the morning. It's unfair to keep them here, it seems to me, past what we've told this one man. We're going to lose some jurors, as you're aware. And the people at first, we thought they might have understood this. But then when we see this list, and they say, well, this is just 3 days, they still don't understand it. We're going to be well into next week, and the problem is going to be as we've indicated. And so I make this motion most seriously. You can still have the ramifications of sequestration, and you'll recall that during picking this jury, you told these jurors not to watch television, not to do certain things, and by and large, they comply with your orders. These people have been here like almost 9 months, and I think they would do that. I think they would welcome it. It would take a lot of pressure off them. We can finish this case. We still should finish it as soon as possible, but it would be a lot fairer for these people if the court would consider doing that. And we've thought about this. All of the defense agrees this would be an appropriate thing for us to do. Otherwise, we do not, on the defense, want a mistrial, and we're going to move in that direction. If we don't, the court has to spend every few moments apologizing. And I don't think you'd like to do that. You made a nice joke yesterday. Nobody laughed. You look vaguely familiar. I didn't see, no, think back, nobody laughed. There may have been a couple of polite snickers, but nobody laughed. And I'm just saying,
I
Your Honor.
got 3 smiles from the regulars.
Well, Your Honor, smile, Your Honor, well, that's a far cry from the laughter that you used to get. You would admit that also. So I'm just saying, Your Honor, it seems to be it's time to do something about it. We've thought about it, and we'd ask Your Honor to consider doing that. We would also like, if this is 3 days witnesses, that means it's going to be Wednesday, Thursday, Friday. Then we need to know the other witnesses. Also, with regard to these witnesses, we need offers of proof with regard to who these witnesses are, what they're going to be testifying about. And Don Thompson's already testified, for instance. He's the officer who handcuffed Mr. Simpson within 30 seconds of his arrival back on his property. He's already been called. So we need to know who they are and what they're going to be saying as soon as possible to keep from delaying further, Your Honor.
All right, why don't you have Mr. Douglas consult with Mr. Darden, get the offers of proof as to the names that Ms. Clark has just given to us, rather than take up the court's time at this point. You sure that those 2 gentlemen can work it out between themselves as to who's who?
Okay, because there are some people who there are no reports at all on, Your Honor. All right. Thank you, Your Honor.
People that I've just mentioned, they have full reports on. Is the court inclined to entertain the sequestration motion, Your Honor?
I've just entertained it. I've just heard it. Do you have?
I'll be brief. I think this takes the cake for the most transparent motion ever made by the defense. Now that they have, everything about Furman has been unleashed, everything that could possibly be said and done about this man has been all over the community, all over Los Angeles. There are posters, there are flyers, there are articles in the papers every day, news, television programs about this all the time. I wonder why the defense wants the jurors to be unsequestered. Gee, I wonder if I can figure this one out. I think anybody can figure this one out. This is, of course, the worst time for the jurors to be.
Ms. Lewis would say this is a real no-brainer.
I wasn't even attempting to say that. But I know it's obvious to Your Honor. It's obvious to all of us what they're trying to do here. And it's absolutely improper. I don't even think we need to address it any further because it's so obviously improper. I will tell you one thing. We will rest by Friday unless the defense motions prevent it, because we have voluntarily pared back our list, having seen the fatigue of the jurors and their desire to go home, which we fully understand. Believe me, fully. So we will rest by Friday, Your Honor. It's up to the defense to finally rest and stop playing games, filing spurious motions, asking for more time on matters that they've been fully prepped on for months. Let's just get this thing done. We'll call Gary Sims. His testimony will take 10 minutes. I can give you an offer right now. Gary Sims' testimony, if it takes more than half an hour, we'll all be surprised.
No, we're talking, no, I'm not interested in that. Just the continued full sequestration of the jury as opposed to the modified sequestration suggested by Mr. Cochran and the plan originally contemplated by the court.
The answer is not to unsequester a jury that will be released into a community that is rife with inadmissible matter and very inflammatory matter. That's exactly why they want them released. The answer is to shut this case down. The answer is to end this trial. That's what we need to do. We need to stop with the endless motions and the endless arguments and the endless, requests for time that, for lack of discovery, now they have it. They've got it all. They have everything. With the impressions that the defense complains of will be made available to them, although presumably they should already know this stuff. Their witness testified to it. No surprises are going to be had here. Now, with respect to our timing, I've indicated to the court that unless we get stopped up by a lot of defense motions, we will be done by Friday. And then the defense has to be made to rest at some point. They, too, have to end their case. And whatever witness they have coming, obviously, a witness coming this late in the game, we're going to have to scrutinize for relevance and admissibility. That shouldn't take very long. If it's admissible, fine. If it's not, fine. And part of the admissibility issue with a witness newly discovered may well be that witness may engender a mini trial. We have to litigate that. That won't take that long. So if everything goes according to the way it should, and everybody just puts on their witnesses and stops talking, we will finish this case, both defense and the prosecution, by Tuesday of next week.
All right, thank you.
I must say, I know the hour's late, thank you. I'm not going to be personal at all. This is just to deal with this motion. We're serious about this motion. I'm mindful of the fact that when we were picking this jury, when the prosecution, the city attorney, and the police released that 911 tape and caused these problems, didn't cause a problem for these jurors. So now we're not worried about what happens in this community. What we're worried about is getting this case over with to the jury. We agree on that aspect. But counsel says, on the one hand, we got to stop all these motions, and she says this mystery witness, whom they know about already, because Ms. Clark turned to Ms. Lewis yesterday, said he must be talking about blank, blank. Peter Neufeld saw her. They know. They've known all along. And in
I thought
addition,
we're arguing sequestration at this point.
Mr. Neufeld saw her do that yesterday. And so,
Counsel, let's not get into
all right,
this.
well, at any rate, the point is they know who this witness is. They should have told us about it earlier at any rate. And so then they argue on one hand, we're going to have all these admissibility hearings, as they did with every one of our witnesses. Keep in mind, Judge, they took, what, 6, 7 months? We took like 8 weeks? I mean, you can't even compare that. So we're very serious about this and would ask you not to give it, I don't think it's a no-brainer. I think when you see the fatigue on those people's faces, not paying much attention, staring off into space, coupled with the problem that lady has, coupled with the problem the juror had this morning, we're at a real crisis point, it seems to me. And so I throw this out for Your Honor's wisdom and thinking. I don't think it's a no-brainer. When you spent this much time and this much effort. And if you think, and I'd be real pleased if we could finish this case, their part, by Friday. If they do that, we'll finish our part as soon thereafter as possible. But I think that it is not a no-brainer. That's the point I wanted to make.
All right, thank you, counsel.
All right, this is not seeing Dr. Popovich and Mr. DeForest.
I didn't hear their names, counsel.
All right, the other thing I have one thing that'll help you.
What's that?
I have the page references through the Xiphine program for Dr. Gertis's testimony.
I
With
have them
respect
already.
to 303. You have them?
I have them.
Okay. Finally, could I request of the court, I will not have an expert, if they're going to deliver these things at 12:30 tomorrow with Mr. Diedrich, I won't have an expert here, and I won't have an opportunity to send them anywhere.
Counsel, we litigated this issue
No, I
already.
understand, but what is the ruling? The ruling is they're going to be allowed to put them on in the afternoon after I alone are looking at these test impressions that
You've
I've never
heard the
seen
ruling,
before?
counsel. You've heard the ruling. All right, 8:30 tomorrow morning, we'll take up scope on the 617 incidents.
I'm requesting adjournment, Your Honor, until Thursday morning for Mr. Diedrich.
Well, you haven't heard Mr. Diedrich yet. All right, one recess.